Hey, how's it going? So now we have to cover what is legal authority. Essentially, there's two types of legal authority. Legal authority, generally speaking, is what we have to argue about, what we base our arguments on to prove or disprove our case. As lawyers, we can't just start making stuff up on the fly, right? We have to use law to support our arguments. Just like in math, you have to show your work, we have to use law to support our arguments. There's two types. The first type is statutory law. That's the stuff that people in the House of Representatives or in the Senate, they get together, they argue about these different bills and whatnot, and then when they decide on something that's good, they pass it on up to the executive branch, to the governor, if it's a state level, to the president, if it's a federal level, and that individual can sign it into law. Once that happens, that becomes statutory law. That means it's on the books, everybody's got to follow it, so on and so forth. In Michigan, you can go to Google, you can type in MCL, which stands for Michigan Compiled Laws, and you could type in statute and code sections and all that kind of good stuff. And you can find all of the statutory law on Google. So for example, you could type in MCL 600.1234, and it'll come up with something. And that's a statute, that's statutory law. The second type is case law. Case law is essentially what the judges decide, or how the judges argue or decide what something means. So let's say it could be in an interpretation of a statute. So the judges could say, we interpret such and such a statute, maybe MCL 600.1234 to mean this, or it means that. When the judges do that, when they write their opinions, that becomes case law. Okay. Now there's two different types of case law, at least in Michigan. There's binding case law and there's persuasive case law. Binding means you have to follow it no matter what. Okay? That means it constricts your case, it binds your case, you have to follow this, the trial judge has to follow it, whether she wants to or she doesn't want to. The second type is persuasive. That means it's just out there, it might influence a trial judge to go one way or the other, but they don't necessarily have to follow it. What distinguishes between a binding case and a persuasive case? Whether it's published or not. And that really only comes into effect when we talk about the Court of Appeals. Any opinion coming out of the Supreme Court is going to be binding because it's Michigan's highest court, is going to be binding. Anything coming out of any opinion coming out of the Court of Appeals can be either binding or can be persuasive. The difference again is whether it's published. So how does a court know, how does the Court of Appeals know if it's going to publish a case? Publishing a case essentially means that something novel happened in this one, and it's important that trial courts and other courts of appeal pay attention to what happened here and are bound by what happened here. That's essentially it. If it's kind of a run-of-the-mill case, happens all the time, these issues come up over and over and over again, and there's really nothing new here, it's just going to be an unpublished case and persuasive. So how do we know what to use when we're arguing in court? The way to think of it is rocks roll downhill, right? So anything from the Supreme Court is going to be binding on the Court of Appeals, it's going to be binding on the Circuit Court, and it's going to be binding on the District Court. And I'm using Michigan. Insert your own state and your own court levels there as well. Anything that comes from the Court of Appeals, say it's a published case, it's going to be binding on the Court of Appeals, and it's also going to be binding on the Circuit Court and the District Court. Let's say it's not published. It does not necessarily mean it's binding at all. If it's not published, it's just persuasive. So let's say that the case came out in 2010. I have a case now in 2015. I find this perfect unpublished case. It has the exact same facts, circumstances, everything is the exact same. I present that to the trial judge. Trial judge can either follow that case or not follow it. Whatever they want to do. Because it's just persuasive. It has not been published. If that 2010 case was published, the trial judge has to follow it. Let's move up the chain. Does the Court of Appeals have to follow anything the Circuit Court says? No, obviously not. Does the Supreme Court have to follow anything the Court of Appeals says? No, obviously not. In other words, think of it like you're in a corporation. You listen to your boss. Your boss tells you what to do. You don't tell your boss what to do. Exact same kind of concept that's going on here. Likewise, and finally, let's pretend we're not in Michigan anymore. Let's pretend we still are in Michigan, but we're using a case from Wisconsin. Do we really care what a Wisconsin judge or Wisconsin lawyers have to say about Michigan law? No, that's automatically persuasive. It could come from the Wisconsin Supreme Court. Does not make any difference. It's just persuasive. Only what Michigan judges have to say, or Michigan statutory law has to say about Michigan defendants or Michigan cases, applies. Anything that happens outside of Michigan doesn't really apply, with the one exception of the Supreme Court of the United States. When we start talking about constitutional rights, the stuff that the Supreme Court of the United States says does apply to the state level. So if the Supreme Court of the United States says that X, Y, and Z is unconstitutional, Michigan courts are also bound by that finding that it is unconstitutional to do X, Y, and Z. That's essentially all you need to know about legal authority, how it applies up and down the chain of command, and that's basically it. Please go down below, click a thumbs up if you like this video, if you found it helpful. Give it a thumbs down if you didn't like it, if you didn't find it helpful. Leave a comment. I'd be more than happy to respond to your comments, just as long as I'm not giving out legal advice. I'm not going to do anything like that. But yeah, other than that, thank you very much for watching. I hope you learned something, took something from this video, and I hope to see you in the next one. Take care. Bye.